Good evening, everyone. How are you all? Hello, Sashi. Okay, everyone, ready for the next lecture? Yes, without wasting of time, we'll start soon. Let's have another 1 minute or once. Yes, online buddies, join soon. Yes, Shashi, hello, ma'am. Hello, mom. Hello. Hello, dear. Your philosophy started. Hello, dear son. Hello. All bacha parties. Okay. So, Vanakkam, Namaskaram, Namaskara, Namaste. This is CS Aarti Panigrahi, directly live from the Mysore city, which is a heritage city. Yes. Okay, fine. So, guys, today we are going to take up the session of law of contract, where we had completed some concepts, and yesterday I left here where the agreements void as being opposed to public policy. Okay, so we had seen the which kind of agreement can be the against the public policy. Okay, fine. Then here this paragraph is telling you that an agreement is said to be opposed to public policy when its tendency is harmful to the public interest, administration of justice, public welfare, morality, or the security of the state, means country. Such agreements are not enforceable by law, even though they may not be expressly prohibited by any statute. As I told you, if any kind of agreement which is harmful against the public interest, against the security of our country, against the justice or morality of our country, of our public, okay, then these kind of agreement will be invalid, though it is not expressly stated by any kind of act or law. Are you getting? It is not necessary it will given a list of the agreement that these are against the public policy. So the scope of the concept of public against the public policy is a wider. Okay. In that yesterday I left here that Geru Lal Parekh versus Mahadev Das Maya. They had made an agreement, guys. A partnership agreement. A partnership agreement they had made of speculative business. What is speculative business? Do you know? Speculation is what? Speculation is what? Of wagering or any kind of betting. Their agreement was involving the betting. Okay. This was the case. Okay. Speculation is what? Satta. We used to say satta, estimation. Used to say, no, like this team will win or this team will win, or they speculated on the horse race and all these kind of things. Okay. So putting the case on someone. Nahi re baba. Wrong. So the speculation business involving betting. So they had made an agreement. So this agreement was not valid. Okay. It was not valid. We are talking here valid versus valid and illegal. Sorry, invalid or void and illegal. So tell me one thing. All invalid agreement will be illegal or what? No. This is the discussion on this case. Okay. Now they are telling involving betting. Though betting is not allowed. Are you ready? It is not valid. It is not a valid agreement, but it is not illegal. It is not illegal because expressly when this case law came, expressly it was not written anywhere that it is an illegal agreement. Are you getting? It is invalid, but it is not illegal, guys. Okay. So this case law, Gerulal versus, what is the name? Mahadevdas Maya. Okay. So they had made a partnership agreement under section 30. It was, that time it was not illegal. So you can say it is invalid, but it is not illegal. Okay. So here, the important note you have to see that agreement opposed to public policy are generally void. Whatever is against public policy, it is invalid, but not necessarily illegal. Okay, na? So thus, while they cannot be enforced in a court of law, they don't allow or they don't always attract legal penalties. Star mark. You can get this. You can get this question in your exam also. Otherwise, all illegal agreements are void, but all void agreements are not illegal. Absolutely right, champ. USD. Yes. So agreement opposed to public policy are generally void, but not necessarily illegal. Thus, while they cannot be, you cannot go and tell if in this betting and all, can you go to the court and you can take the help? You cannot. But that doesn't mean if somewhere it is happening, it is punishable. Like Goa and Sikkim, even it is allowed. In Goa, casinos are there. They are doing the betting, no? The wagering things are going on. So that is allowed also. Goa and Sikkim, these states, like these are the UT. Yes. Huh? Lottery is also like this only, invalid but not illegal. In some states, too, it is like it is allowed also by the government. Okay. Yes. Yes. That's why the discussion is what? Yes, Kerala also has. Yes. So the thing is, the discussion is whether all agreements are all invalid agreements are illegal or not. So no, it can be invalid, but it cannot. All agreements cannot be. All void agreements cannot be illegal. There will be no legal penalties on that. Okay. Then next topic is, so we had completed this topic, agreement, regarding agreement, lawful object, consideration, offer, acceptance, consideration, and all. Okay. Now we are going to touch a new topic, discharge or termination of contract. Now you had made a contract. Now how you will discharge that contract? Okay. You had made a contract. Discharge means what, madam? How it will complete. How you will be discharged from your liability, guys. That is called the discharge of the contract. If say suppose somebody is having right, somebody is having obligation. How the obligation will be discharged? A had said something to do B that I will do this for you. A had done that, B had paid the money. This is discharge. They are discharged by their obligation. They got their rights and all, right? So how it can be discharged? So if an agreement or contract is there, how it will be discharged? First of all, very simple funda is by the performance. If the both parties will perform their duties and obligation, it will be discharged. Okay. So let's see this topic here. Okay. Yes, after completion of the obligation. So discharge or termination of the contract. A contract is to be discharged or terminated when the rights and obligations arising under it come to an end. Somebody will having the legal right, somebody is having the legal obligation, everything will be fulfilled, it will be discharged, contract will be discharged. Once a contract is discharged, the parties are released from their contractual duties. What happened? What maza you got in this? A contract may be discharged in various ways. The most common being discharged by performance. Got it? Both parties or any parties involved in the agreement or contract, they will perform their duties, agreement will be discharged. Second, performance of contract, section 37. Section 37 provides that the parties to a contract must either perform or offer to perform their respective promises unless such performance is excused under the provision of the Indian Contract Law Act or any other law. What it is saying that the agreement or a contract can be discharged by the performance unless such performance is excused under the provision of Indian Contract Act or any other law. If Indian Contract Act or any other law is telling you not to do this, not to perform, then it will be discharged by performance. If such kind of act is prohibited by law or under contract law, then if you are performing also, it will not be considered because it is prohibited by law. This performance is excused. You have not to perform. Got it? Yes? Next. Performance is the normal and most desirable. The same thing they are telling here again. Performance is the normal and most desirable mode of discharging a contract because once the party fulfill their obligation, the contract automatically comes to an end. In case the promisor dies before the performance, if in case promisor dies before the performance, his legal representative are bound to perform in contract unless the nature of contract indicates that personal performance was intended. Anybody can guess it? Chalo bolo. Online buddies, you can tell this. What does it mean? In case of promisor dies before performance, if one person A had promised to perform but he died, who will perform that? Who is bound to do? The legal representative. They will do that. Any son, daughter, or any other person who he had mentioned as a legal representative. Okay, now tell me of the contract. This is the simple thing. Then unless the nature of the contract indicates that personal performance was intended, means what? It means, guys, it is written in the contract that personal performance is must. We need in this contract, with whom I am doing this contract, that particular person have to do it. And personal performance means what? Say suppose Mr. A is a painter. Now tell me, guys, if he will die and his son is cricketer, okay? Now tell me, this agreement A had done with B to paint something for B. Now A died. Can the legal representative perform this painting performance? ये एक थप्पड़ लगाऊंगी मैं तुमको. A is painter, his son is cricketer. So painting work son can do. You Gen Z, the chat GPT era में तुम mind use ही करना भूल गए हो. You are not using your mind. And that 12th standard जो तुम्हारा mugging up का जो फंडा है. A is painter, son is cricketer. Can he perform painting? No. So this is what the personal skill. Okay, that is what the personal skill involved and personal performance. Personal performance was intended. Okay. Yes. A dies. As soon wife or any legal representative must perform the obligation if it is mentioned in contract. Shashi, listen to me and tell me. Don't repeat my concept there. Okay, anyhow, you can involve, definitely you can participate in this. Fine. So X promises to deliver a horse to Y on payment of 1,000. Before the date of performance, X dies. Who can give the horse, guys? X representative are bound to deliver the horse and Y is bound to pay 1,000 to them. This is the example of the where personal skill is not required. To deliver the horse, it is not a personal skill. Okay, personal performance, anybody can deliver. Okay, got it? Now you will get the other example also further. First of all, you got it, this line you got it. Now indicate that personal performance is intended. That time the particular person can do. Now say suppose A died, he was a painter and he was supposed to do painting. Now A died means B have to cancel that contract. It cannot be taken by their legal representative. Okay, yes. Tender of performance, section 38. Sometimes a promisor is ready. Guys, did you get that? This performance of contract, by the performance we can do aram se anybody. If the promisor died, who will take up this? The legal representative can take up the any kind of work, but what should not be involved? If the personal skill, personal performance is involved, legal representative cannot do that. Are you getting? Yes. Next is what? Tender of performance, section 38. Sometimes a promisor is ready. Okay. Who is ready? The one who had told to do something. Promisor is ready, willing to perform his obligation, but who is not ready? Promisee refused to accept the performance. A had said to B, I will do this. A is the promisor, B is the promisee. Now A is willing to do something, but B is refusing. Okay. A promisor had said to B, I want to perform. Promisor and promisee. Okay. Now, but B is refusing. Okay. In such cases, the promisor may make an offer to perform known as tender of performance. A is giving that I will perform, I want to perform, I am willing to perform. Means he is giving the tender of performance. Are you getting? Tender of performance meaning? Already A had said, I will perform this for you, you pay me this. Okay. Now A is ready to perform, B is promisee, B is telling I don't want your performance. Okay, what is further we'll see. Now, so when A is telling I want to perform, that is called the tender of performance. Tender of performance. Now, a valid tender has the same effect as actual performance and discharge the promisor from further liability. If A is telling, first of all, the contract was there in between A and B, that A will perform, B was ready. That was the actual contract. Now B is refusing to take up the performance, but A is again telling that I am willing to perform. That is called the tender of performance. So what is the effect of both? Both is having the same effect. A was ready earlier also and A is ready now also. Means the actual performance and tender of performance is the same effect. Got it? Yes. Now, for a tender to be valid, it must be unconditional. If somebody is telling, A is telling to perform, it should be unconditional. Be made at a proper time and place. Say suppose now A wanted to perform, but it should not be like beyond the time, like after many years and all, like not like that. So it should be at the proper time and place. Show that the promisor is ready and willing to perform the whole promise, not the half promise. Okay. Then give the promisee a reasonable opportunity to inspect the goods where goods are involved. Means now who is the promisee? B. So in this case, they are telling if promisee wanted to inspect the goods, if in this contract goods are involved, promisee wanted to inspect the goods before the performance. So let's have a opportunity, let's give the opportunity to promisee to check the goods. Okay. Now B made the proper person entitled to receive the performance. Who wanted to receive the performance? That person should be a proper person, appropriate person. Okay. Yes. Fine. So then next is what? Did you get this? Tender of performance, section 38. Section 37 is the performance, discharge of the contract by performance. Okay, next is what? Who can demand performance? Now, who can demand, guys? Now, A is there. Say, suppose in our example, A is the promisor and B is the promisee. So, who can demand? Who is ready to perform? Who is ready? A. Who wanted the performance? B. Okay. So, who is liable? Who can demand the performance? Who can demand the performance? B can demand. If B died, then who can demand? Who can demand? Legal representative can demand. Okay. And one more fellow will come here, assignee. Assignee means what, guys? Assignee means what? B had given right to assignee to take this performance. Mr. B is a businessman. He is busy. He is out of country. Legal representative can take. If B died, legal representative can take. Or if B had said, I am busy, Mr. Shyam, his manager. Mr. Shyam, his manager. So who had given this right? B had given this right to Mr. Shyam, and Mr. Shyam will be the assignee. Mr. Shyam will be the assignee. Okay, means somebody will give the right to take up the performance. Okay, yes, one full topic is there for the assignee, that also in detail you will get. Okay, yes. Then who can demand performance? Let's see here. As a general rule, only the party to whom the promise is made can demand. Only generally, who can demand? Only B. Only B can demand. A stranger to a contract cannot enforce it. Stranger means what? Say suppose he is having the friends. B friends are X, Y, Z. Whether they can demand performance from A? No. Okay. Next. However, an assignee of a contractual right can demand performance in the same manner as the original promise. So who can demand? Assignee can also demand, and even further you will see the legal representative can also demand the performance. Okay. So the B can demand or assignee can demand. No stranger can demand. Okay. Next, effect of refusal to performance wholly. Section 39 is telling, if say suppose A and B, our example, A is telling I will not perform complete performance. Section 39. When one party refuses to perform his promise or disables himself from performing it completely, either incomplete or completely, he is telling, he is refusing that I am not able to do, the other party may terminate the contract. Means B can terminate the contract. Okay, na? B can terminate the contract. Okay. Now, however, if the promisee, who is promisee? Who is promisee? Bega. B is promisee. However, if the promisee by words or conduct accept the continuation of the contract despite such refusal, the contract remains in force and only compensation for loss may be claimed. Anybody can tell me? Chalo batao. Can you interpret it? Yes. Bolo bhai. Can you interpret? Yes. You want to try? Tell me. If the promisee by words or conduct accepts the continuation of contract, means what? A first refused. A had refused first. Then A said, okay, I will do. That is called continuation of the contract. Now, when later on A said, I will continue, I will perform. So B had accepted it. B can first rule is telling we can reject the contract, but B don't want to reject the contract. We want to continue it because A want to perform. So if the promisee B by words or conduct accepts the continuation of contract, B is accepting the contract, continuation of contract. Despite such refusal, means after A's refusal also, when B is continuing accepting the contract remains in force. It will be as how it was, and only compensation for loss may be claimed. Say suppose A had refused for 2 months. So B suffered some losses or any kind of fine. So now A is telling I will perform and B is accepting. Let's continue it. Then what B can ask? What penalty? This losses he can ask from A. Okay. Now see this line. However, if the promisee by words or conduct accept the continuation of contract despite such refusal, the contract remains in force and only compensation for loss may be claimed. Are you getting now? Yes? Any doubt in this? Any doubt you can ask? No? USD? Yes? Let's see the example. It will be more clear for you. X, a singer, agreed to perform on Y's theatre twice every week. How many? Twice every week for how many months? For 2 months. On one schedule, on one scheduled performance day, X deliberately, means intentionally, remains absent. Deliberately, intentionally, X didn't go to perform. Y may terminate the contract. What is the first rule is telling? Y is having the option to terminate the contract as per the Contract Act 1872. X or Y or A and B. So B is having all the rights or Y is having all the rights to terminate that contract, cancel that contract. Okay. Now, if Y allows X to continue performing afterwards, after the absenteeism also, if Y is allowing X to perform, Y is deemed to have accepted the continuation of the contract and can only claim what, guys? The compensation for the loss caused by the missed performance. If the scheduled day there were tickets, Y had who had collected? Y had collected and Y had refunded that ticket. Say suppose that day he lost 10,000 rupees, he made a 10,000 rupees of loss. Okay, now how much Y can collect from X? 10,000. Is it clear, guys? So this was the effect of refusal to performance wholly. Got it? Yes. Next, by whom must a contract be performed? By whom must a contract be performed? Section 40. Where the nature of the contract shows that personal skill, already we had discussed it, personal skill, knowledge or qualifications of the promiser are important. Who is the promiser? Let's take an example of A and B. In our example, A is promiser, B is promisee. Okay. Now, where the nature of contract shows that personal skill, knowledge and any kind of qualification of promiser, the promiser himself must perform the contract. Got it? Who will perform then? The promiser only. The promiser only. In all other cases, performance may be carried out by the promiser or legal heir or legal representative or any competent agent. Okay. In all other cases, performance can be taken by A's legal heirs, legal representative, or by A's manager. He is the competent agent of A. Okay. So it can be taken by anyone. But if the personal skill is required, only the promiser have to perform. Clear? Illustration. X promises to pay 1,000 to Y. The payment may be made by the X or by someone on behalf. X promises to pay. Either X can pay or anybody can pay. But if X promises to paint a portrait for Y, since the contract involves personal skill, X himself must perform it. If X dies, then who will perform? Nobody. Contract will be cancelled. Clear hai bhai? Is it clear? Then why it is needed, guys? What is the need of these things? Why you guys are studying this? Tell me. Why? ಯಾಕೆ ಸ್ಟಡಿ ಮಾಡಬೇಕು ಇದು? ಯಾರು ಪರ್ಫಾರ್ಮ್ ಮಾಡ್ತಾರೆ? ನನಗೆ ಏನು? ಯಾರು ಮಾಡಲ್ಲ. What is the use of this? Tell me. ಯಾಕೆ ಸ್ಟಡಿ ಮಾಡಬೇಕು? ಬೋಲು ಹೇಳಬೇಕು. The contract, without contract there will be no commercial. What we are telling? Contract, legal relationship. Legal relationship created in which kind of transaction? Business and commercial transaction. Now what you are thinking? Commercial transaction is 2 rupees, 4 rupees, 10 rupees, 1,000 rupees. Okay. Now you tell me, there are transaction of million, billions, crores. चलो तुम्हारे हिसाब से ले लेते हैं. Crores also. If you are not aware about all these things, for yourself, if you are starting any kind of your own firm, you are starting, you are doing your own business, you are suggesting, you are advisor to the businesses, you are advisor to the corporate, how you will get to know these things? How you will suggest if you are not aware about it, these things? How you can get to know whose liability is there? In this situation, what we can do for our our employer, what we can do for our client. If you are not aware, client is aware. Client is studying law of contract. Who is studying? For what? For what the client is paying you, or for what your employer is paying you. If say suppose you had done any kind of mistake, who will bear the losses? You will be fired from that company. These look small, but it is the impact is like you can get the help of the court for any small thing. So first of all, you should aware about it. Then it becomes interesting or not, you tell me first. So for life, why you are doing something, no? That is very, very important. Why? In all things, you should search why. For anything. If you say, suppose you are enjoying, you are going for a trip. What you are getting there? You are enjoying, no. So why I am going to this trip? That you should understand. Are you getting? Why I am studying this? Just to pass exam, CS exam pass करने के बाद, you are not going to utilize this. You have better knowledge. Anybody, I am telling you, any professional should understand this contract, sales of goods. So why you are studying anything, why you are doing, if you will understand that day, you will start asking you that why. Same like any relationship. शायद तुम्हारी स्माइल बहुत जल्दी आ जाती है. Any relationship, anywhere you are sitting or talking, what you are getting out of it, whether your purpose is solved here, you want a companionship, you want a happiness, or there you are wasting your time. You ask in each and everything. If that is not serving you any purpose, just leave that and move further. For everything, I have to come there only where तुमको समझ में आता है. Example. Okay, from there only you will learn the business first. Okay, guys. So this is not something we are section 13, 37 we have to do. If say suppose you had made a big contract for a company, now that person died. ಆಮೇಲೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಆರ್ತಿ ಮೇಡಮ್ಗೆ ಕಾಲ್ ಮಾಡಿ ಏನ್ ಮಾಡ್ಬೇಕು ಮೇಡಮ್? ಸೆಕ್ಷನ್ 37 ಆದ್ಮೇಲೆ ನಾನು ಓದಿಲ್ಲ. 39 ಏನ್ ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ? ಏನ್ ಅಸೈನಿ ಹೇಳ್ತಾರೆ? ಏನಿದು ಅಸೈನಿ ಅಂದ್ರೆ ಅವ್ರದ್ದು ಸನ್ ಡಾಟರ್ ಮೇಡಮ್ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಗೊತ್ತಿಲ್ಲ ನನಗೆ. ಹೂ ಇಸ್ ಅ ಕಾಂಪಿಟೆಂಟ್ ಏಜೆಂಟ್? ಅರೆ ನನಗೆ ಗೊತ್ತು ಲೀಗಲ್ ಹೇರ್ಸ್. ಹೂ ಇಸ್ ದಿಸ್ ಬ್ಲಡಿ? ಸಾರಿ, ಕಾಂಪಿಟೆಂಟ್ ಏಜೆಂಟ್. ಓಕೆ, ಸೊ ದಟ್ everything you have to understand. That is our purpose, online buddies. That is our purpose. You have to understand completely, and that's why we are telling you these things, because you have not to only pass this exam, you have to become a proficient leader in your profession. Got it, guys? And trust me, you just start asking why, and then you see that what magic created in your life. And every time and whatever you are doing, no, that will be purposeful. ठीक है? Then you have not to just for the test and passing exam I have to study. Then that will be not the focus. Okay, guys? Yes? So, partly performance, wholly if somebody is terminated, what will happen? Personal skill we had seen. Then by whom must a contract be performed? Okay? Now here I said, the personal qualification we had covered in section 40, and we had seen two examples of either generally you can take it the performance by someone, or that particular person is required, the one who is having the personal skill. Okay, now devolution of joint liabilities. Now guys, there are some more person who is having the liability. Say suppose there are joint liability holders, means not even one person is there, 2 to 3 person are there to who have to perform. So devolution of joint liability, say suppose A, B, C, 3 people are there. A died, now who will perform? Then what about A? So the devolution of joint liability means what? How the liability will shift to someone, to joint holders in certain circumstances. So what are these circumstances and who will take the responsibility? We are going to see in section 42 to 44. When 2 or more persons jointly make a promise, they are known as joint promiser. Okay. Now not only A is there, A, B, A, B, C, D. Okay. All these people are the joint promisor. Then joint promisor, they have joint obligation or liability. So when two or more persons jointly make a promise, they are known as joint promisor. Section 42, liability of joint promisor. Unless a contrary intention appears from the contract. Unless a contrary intention appears from the contract. This is your contract. What is generally terms and condition the normal contracts are having, if that is there. But unless a contrary intention means what? Contrary means what? Opposite, anything else than this. So say suppose you are making a contract little bit more modified, putting more terms and condition. Are you getting? General I am discussing. Generally the dissolution of the partnership, if partners died, so they dissolve the partnership. Partners died or somebody is retiring, they dissolve the partnership. So that is a normal format. But in your agreement or contract, you are writing that say suppose 4 partners are there, but if somebody will die or retire, we will continue this partnership. This is called the contrast. Something else you had mentioned in your agreement or contract. Are you getting? Something else which is not general. Okay. So unless a contrary intention, it is not a general intention you are having the other intention also. One more example I will give. In partnership, 4 partners are there. Usually in the partnership, all partners are allowed to participate in the business or not? Tell me, general. They are allowed, all 4. But you are making an agreement that only Subramanyam will do that. Only Subramanyam. All 3 are busy in their work and Subramanyam is capable to run that partnership. So you can mention in that Subramanyam will do everything on behalf of all partners. It can be done or not. So this is what? This is called the contrary intention. So wherever in law you will see this, unless a contrary intention means what? There will be something else which is not a general format. By your discussion, you have some other intention you had put in your agreement or contract. Did you get this? Yes? Yes? Otherwise, simply you will go, what is the meaning of this? What question is there? They are considered as single promisor or different? No, they are joint promisor. They will be considered as single promisor only, not single promisor. Joint promisor for the single purpose. That will be the correct thing. Okay. For the single purpose, they will be taken as joint promisor. Okay. So guys, unless a contrary intention appears, means there is, say suppose any other intention is not appear, then from this contract, generally what will happen? All joint promisors must perform the promise jointly. On the death of one promisor, his legal representative become jointly liable with the surviving promisor. Means what? A died. When A died, so legal representative with these people are called surviving promisor. Are you getting? Yes. So on the death of one promisor, his legal representative become jointly liable with the surviving promisor, and after the death of all promisors, their legal representative remain liable. If everybody will die in this A, B, C, D, so then who will perform? Legal representative of all the joint promisor will perform the promise. Yes? If there is no one, so there will be assignee, there will be any competent agent. That's why I said promisor, if not him, legal representative, legal heirs, or any competent agent. Means who is competent agent means what? The agency relationship will come here. Means on behalf of A, who will perform? The agent will perform, and he should be capable of taking this agency. Are you getting? Otherwise, any assignee, A had given this assignment to somebody else, that person will be called the assignee. Clear? Yes. After the death of all promisers, so we had finished. Say suppose if nothing is written there, then this is the general rule. Okay. If anything is written there, say suppose, now we can take the example. If A had written, told the intention, I don't have legal representative, you do one thing, you guys can take my property and you only do the performance. He can put it on or not. He can put in the agreement, A can put in the agreement that you take my property if I will retire or if I'll die or in any case, and you can pay by that. You can perform by that property because I don't have any legal representative. And that is called the unless contrary intention was involved. If not intention involved, then simply you can tell these 3 points in the absent or death, they can perform. Is it clear? Yes. Clear? Yes. Let's move to the section 43, right of promisee. Right of promisee. Now we are talking about whom? B. Our example is A. For A we had completed. Now we are talking about B. Right of B. The promisee may, in our example, B is the promisee. The promisee may compel any one or more of the joint promiser to perform the entire promise. Right? The promisee is having the right. The promisee can compel, he can ask or she can ask any one or more people to perform the promise. Okay, that is the right of promisee. Now, a joint promiser who perform the whole obligation can recover contribution from the other joint holder. Let's take this example. A, B, C, D, they are the joint promiser, and X is the promisee. Okay, X is the promisee. Now, X is demanding the whole performance from D. Why? Because the X is having right. Section 43 is giving the right to X, promisee, may compel any one or more. Are you getting? Now, in this case, say suppose X is demanding the performance. X is thinking that D is the eligible person to perform it well. Okay. So, now X is asking from D. Okay. Now, D had performed, guys. Now, tell me, D had performed and he spent his money only in the performance. Now, D can take this money from ABC or not? Yes, he can take. Okay. So, this is that. So, the promisee may compel any one or more of the joint promiser, and a joint promiser who performs, say suppose in our example, who had performed, guys? D. D had performed the whole obligation, can recover contribution from the other joint promise. D had performed everything, then D can recover it from ABC. Clear? Yes? Yes, what doubt you are having? Akash. Shreya Akash, please ask. Shreya Akash, what doubt you are having? So, related to this illustration is there, X, Y and Z jointly promised to pay how much? 6,000 to A. Please ask your doubt. To A may recover the entire amount. Just a second. What is your doubt? Clarify again is you have to go through these points. These 3 points. All joint promiser must perform the promise. Okay, you wanted to ask this one. No. Joint, if somebody won. See this example. I'm just clarifying again for you. Right of promise. Yes. Right of promisee. Let's see. X is our promisee. X is the promisee. X is having right to take up the performance from A, B, C, D, anyone or all of them. Now, say suppose X had taken performance from D and D had completed that performance and he spent some money also. Say suppose spent 1 lakh rupees in that performance, or he spent goods or anything. Now, D is having all right to recover this money from the A, B and C. Are you getting? USD or not? Yes, Shreya Akash. Now, if you have any other doubt, you can ask me. Let's take this example. It will be more clear for you also. X, Y and Z jointly promised to pay how much, guys? 6,000 to A. A is who? A is the promisee. A may recover the entire amount from any one of them. X, Y, Z. Koi bhi. Any one of them. Now, if Z pays the whole amount, who had paid? Z had paid whole the amount. He can claim contribution from X, Y according to their respective shares. Yes. Done? मजा आ रहा है? So never think that what we will do with this. If any mistake you will do, and if anybody, your client will get the fine, then it will go to your reputation, guys. Yes. Lengthy topic. Now release of joint promisor, guys. Some people are sitting here to time pass or what? Online. Okay. Yes. So release of joint promisor is what, guys? Where the promisee releases one joint promisor, the remaining joint promisors are not discharged from the liability. Where the promisee, who is our promisee, you know now, okay, releases one joint promisor. Let's take some promisee. Sorry, promisee. Release of joint promisor. Yes. And who will release the joint promisor? Where the promisee releases one joint promisor. So our promisee is X, okay? And there are joint promisor and promisee is 1. So where the promisee releases one joint promisor, the remaining joint promisors are not discharged from the liability. Now say suppose X had released D from the liability. X had released that, okay? But what about other? They have to perform, okay? Further, the promisor who has been released, who has been released continues to remain liable to contribute towards the liability of the other joint promisor. Yes. The promisor who has been released, who is released in our example D, is remain liable for what? For the contribution. Though he will not perform, but what he will do? He will contribute. Why? Because he was the joint promisor. Say suppose 4 people are there and one person got accident and he is now 2 months on the bed. Whether he can perform? He can perform. Say suppose it is required like physical presence for that work. Say suppose they had taken a contract to build a building. Okay. Now out of 4 people, 3 are there, but one person got accident. Now the X had said, let that person discharge. I don't have any issue if A, B, C will perform and D will not perform. I don't have any issue. But he is liable to contribute to other promisor. Why they will do on behalf of him? Are you getting? So the law is saying that still this promisor is remain liable to contribute towards the liability of the other joint promise. Okay. Now, thus release by the promisee affects only the relationship between the promisee and the released promisor. Means what? This relationship is in between D and X. The release by the promisee, who is the promisee? X, affects only the relationship between the promisee and the released promisor. Who is the released promisor? D. And who is the promisee? X. And does not extinguish the liability of the remaining joint promisor. If X, the promisee, had said that D is not capable of performing, he is physically disabled right now, I am giving him, I am making him free from the liability. That relationship in between D and X, there is nothing to do with the ABC. Is it clear? Okay. So that's why they are saying the release by the promisee affects only the relationship between the promisee and released promiser and does not extinguish the liability of the remaining joint promiser. Okay. Devolution of joint rights. Joint rights. A promise may be made in favor of two or more persons jointly. A promise may be made in favor means here one person is a promiser and how many people are the promisee? Two or more people can be the promise. A promise may be made in favor of two or more persons jointly. Such persons are known as joint promisee. What happened? What happened? Water. Yeah, you can go. Go. इतने सारे सेक्शन पढ़ के प्यास लग गई. Okay. Now we are having joint promises. Okay. In the absence of a contrary intention. Now you are getting no. If there is no contrary intention, so what is the general thing? Contrary is the opposite to or contrast to general rule. Okay. So what is the general rule here? What is the general rule here? In the absence of a contrary intention, all joint promises are entitled to claim performance jointly. Okay. If there is nothing mentioned specifically that only X can ask for performance, so it means who can ask? All promises can ask. X, Y, Z, all three can ask. If one of the joint promises dies, अरे यार, बेचारों को मारे जा रहे. किसको मारना है बोलो? एक्स को मार दें. ओहो, क्या बात है, क्या बात है. I can understand your emotions, सुब्रमण्यम. एक्स को तो मार डाले. Yes, सुब्रमण्यम एक्स को मार दें. वैसा ही है सुब्रमण्यम. चलो. वह मस्त आंसर दिया है एकदम to the time. Okay, so then what we'll do? Frustration, ma'am. Okay, yes. So what we'll do? X को निपटा देते हैं, ठीक है? So so if one of the joint promises dies, say suppose X, his legal representative jointly with the surviving, his legal, who's X? X legal representative jointly with the surviving promises can demand the performance same. Their promiser legal representative were bound to perform. Here they can ask the performance. Okay, so legal representative can demand the performance. After the death of all joint promises, their legal representative acquire the right to demand performance from the promiser. Simple. Yes, simple hai. Examples: X promises to repay 1,000 to Y and Z jointly. Both Y and Z can demand repayment generally. If Y dies, Y's legal representative plus Z can jointly claim the amount from X. Yes. Last topic of today is assignment. Yes. What is assignment, guys? Assignment means the transfer of right and benefits under a contract from one person to another. Assignment is what? Transfer of rights and benefits under a contract from one person to other. Like in A is the promiser, B is the promisee. Okay. Now B is want performance from A. B is not free to take it. B can give it to X. B can give it to Y, to anyone. anyone can become the assignee. Okay, na? So, as a general rule, guys, the rights and benefits arising out of the contract may be assigned. What you can assign? Rights and benefits. Right and benefit. Now, B is telling, say, for this contract, I have to pay 5 lakh rupees and I am getting car of A. Okay. Now, B is telling to X. B is telling, I'll not make you more confused. Confusion nahi karna either. So, B had asked to X, for 5 lakhs, I will get the A's car. So, instead of me, you pay 5 lakhs and you get the A's car if you are interested. Okay. So, who will get the right and benefit? The assignee. Assignee will get the rights and benefit. Okay. So, as a general rule, rights and benefits arising out of a contract may be assigned and the assignee become the entitled to demand performance from the promisor. Clear? Who can demand performance? X can demand the performance from A. Now, who is the assignee? X is the assignee. Okay. Now, for a entitled to demand performance from the promisor for a complete and effective assignment, it must be made through an instrument in writing. It is not simply B will say to X and X go and demand. No, there should be an agreement or any kind of instrument, means any kind of document in writing. Okay. Now, however, contractual obligation, this is important, guys. Now, you tell me one thing. B had assigned it to X. Now, performance who will do? A. Whether we have to ask to A, he is interested to give his car to X or not. Here is a very interesting twist, I'll tell you. We have to ask or not? Yes or no? Why? Hare, X can be the X of A, no. Now here, this X can be the X of A. Then A want to do this transaction with X? No, no. You didn't get it. You got it. Yes. So, if B want to give it to X, that चलो अब इधर settle करते हैं. आकाश, हेमंत, हाँ. And this one is Shreya. Now, Akash have to give the car to Hemant. Now, Hemant said, I don't want this car. Shreya, you take this car from Akash. Now, Shreya is the X of Akash. Whether Akash willing to do this transaction with assignee or not? No, na? Definitely. So, Hemant have to ask to Akash or not? First, that I am going to assign this work to Shreya, whether you will do this transaction with her or not. So it is important. I am not saying this. You just see here. I am not saying anything. What is related, I am saying that only. However, contractual obligations and liability cannot ordinarily be assigned without the consent of other party. This is because a person cannot be compelled to accept performance from someone with whom he never intended to contract. So here our Akash never wanted to do this transaction with who? Did you get this? So whose consent is important? Akash consent is important. USD, Shreya Akash, where you went? Shashi is suggesting here, don't do any transaction with X and don't do the same mistake. Okay. Shashi, this is law of contract. Experienced. This is something new. Yes, another 1 minute left. Let's see, guys. Let's conclude it. If the other party agrees to substitute a new person, this is also very, very important, this paragraph. If the other party, our Akash is ready to substitute a new person instead of Hemant, he is ready to go with the Shreya in place of the original contracting party, means A and B. A is ready to go with C, the new person. A new contract comes into existence and the old contract is discharged, means A and C is the new contract. And which was the original, guys? A and B was the original contract. Now a new contract comes into existence and the old contract is discharged. This substitution is known as novation. Novation. New person. Huh? Huh? Yes. Without second paragraph is telling B have to take the consent of A whether you wanted to go with this new one. अरे वो X वाला तो example अपना था ना, to make it understand, to make it fun. कि भाई why Akash will go with the X, that's why. So that was the example. So you will remember when the exam will come. Okay, but every time, anytime, the law is telling that the person who is giving this assignment, he have to ask to the other party. Other party is the promisor. So whether A is ready to do it with the C, this contract, then only it can be assigned to C. Are you getting? Yes. And this concept is called novation. Why? Because A and B original contract is terminated, discharged. Just a second, original contracting party, a new party come into existence and the old contract is discharged. Now there is no liability of B. There is no discharge. Why we are using this word? Discharge. Why? Now there is no liability of B. Why? That's why consent is important. Later on, say suppose C or Shreya had not given 5 lakh rupees. Only how much he had given? 4 lakh. Now whether A will go to the B, whether A will go to the B, that you give me 5 lakhs, he is not giving. Why he will not go to the B? Why? Why? Because he had taken the consent first. Do you want to go with C? Then only. Everything is having the reason. Are you getting? Already we had taken the consent of A that I am assigning C. Will you go with C? A had said yes. In the second paragraph, A had given the consent. Then only B is giving this to C. Now B is discharged. There is no original liability of B towards A. Now A cannot ask anything from B. He have to ask from the C. Why? Because he had only given the consent. Correct? Yes, USD. Enough for today. We'll meet in the next class. Bye-bye. Thank you so much for the patience listening, everyone.